Premier Scott Moe saying he will invoke the constitutional notwithstanding clause to force through a controversial new policy about gender identity and the use of specific pronouns in schools.
October the 10th, we'll reconvene the legislature, obviously go through with the proceedings we have. This will be the focus of reconvening the legislature, is to introduce and pass this piece of legislation on parental rights, protecting parental rights.
So for a closer look at the legal perspective, we are joined by Adam Goldenberg, legal lead for You Are Pride. Good morning to you. Good to have you on today.
Good morning, Lindsey. Thanks for having me.
All right, so I want to jump in because this announcement came after a judge had granted an injunction hitting pause on the new policy that requires parental consent when children under the age of 16 want to go by different names and pronouns at schools. So what does the notwithstanding clause do?
Nothing immediately. So the government actually has to convince the legislature, a majority of the members of the Legislative Assembly in Regina, to vote for legislation that contains a notwithstanding clause, allowing them to override the Charter of Rights and Freedoms and enact this policy despite its unconstitutionality. And let's be clear about what that means. The legislature, a majority of MLAs in Saskatchewan, would have to vote for a piece of legislation that contains a provision saying this goes into effect even if it overrides, it violates the charter rights of children. That hasn't happened yet. As of today, in Saskatchewan, students can be known by their chosen names and pronouns in schools, even if they come from families where they can't obtain parental consent, or they're not yet out to their families, or they're not yet out to their parents. That's a good thing, and that's the reality in Saskatchewan today. The announcement from the Premier yesterday has no effect on that whatsoever.
Canada is the first country in the world to provide census data on transgender and non-binary people. Adam, in 2021, just over 100,000 Canadians over the age of 15 define themselves as transgender or non-binary. So when we look at that stat there, the one that's on the screen for everybody, that's about 0.3% of our population. But we're seeing constitutional cases in Saskatchewan, new policies in New Brunswick, and conversations in Ontario at the federal level. Do we know why this issue has suddenly become front and center? And are there any specific cases of harm done to children under the existing rules that we're aware of?
So there was evidence filed in court in support of the government's position opposing the injunction that was granted yesterday. And the court essentially finds that none of the harms, the terrible scenarios the government told the court would happen in the absence of this policy, were supported by evidence. And we argued in court that this was a solution in search of a problem, and that's what the evidence tells us. What's scary, though, is that as you just showed your viewers, you've got a situation here of a tiny minority of students who are directly affected by this policy. It's not just the gender diverse students as a whole who are affected by the consent requirement. It's really only those students who are gender diverse and who have the misfortune not to have supportive parents that are going to be out at school or out to their teachers or a specific trusted adult for any length of time, really, without their parents being involved. Those are the kids whom the court found were going to be irreparably harmed or at risk of irreparable harm, according to expert evidence, if this policy were not put on pause. So what the government is now saying is that we don't care, basically. We don't care about that irreparable harm to that small number of students. We're prepared to do that for whatever. I'm not an expert in Saskatchewan politics. Clearly, the Moe government would rather be talking about this than something else. And so this is their strategy, to take that out on a tiny minority of kids whom the Supreme Court of Canada recently decided in a case called Hansman are among the most vulnerable young people in our society. That's reprehensible. It's unconscionable. It's not what the notwithstanding clause should be used for. And it's something for which, frankly, the government of Saskatchewan and anyone in that legislature who supports this proposed legislation is ultimately going to look back and think, gosh, that was not a good call that we made to support that back in those days. This will not age well, just as every other regressive and discriminatory action by a legislature has not aged well in our history.
So, Adam, in terms of your organization, you are the legal lead for You Are Pride. What are your next steps?
So our next steps are to continue with our case. So You Are Pride, which is my client, has a deadline of the end of next week to file our additional evidence in support of our underlying case seeking to have this policy declared unconstitutional. The government has the same deadline. We're going to meet our deadline. We expect them to meet theirs. It's important to know that the policy actually hasn't been declared unconstitutional yet. The government still has a chance with their excellent lawyers, and they do have excellent lawyers, to make their case, to try to persuade the court that they have done something constitutional by enacting this policy. That decision hasn't yet been made. So once the evidence is in, we'll potentially cross-examine each other's affiants, including our experts on each side, and then we'll have argument in November. So that's the timetable that the court has established. And since as of right now, nothing has happened that would change that, onward we go.
Adam Goldenberg, we appreciate your thoughts this morning. Thank you.
Thanks for having me, Lindsey.
Hey, thanks for watching. If you liked this, be sure to subscribe here, or you can check out more Your Morning videos right here.